that an IT service provider that gets engaged with someone regarding backup services as to what is the scope of that duty, notwithstanding the existence of a written contract. And I think that what our market suffers from is a great misperception that the duty of the MSP is ensure that their customers' environments are free from the criminal acts of third parties.
MSPs are getting sued. Actually, that's not even correct. IT providers are getting sued. The question we ask today is, are those IT providers really MSPs, or are they something else? And regardless of whether they're an MSP or an IT provider, we'll get into that shortly, the question then becomes, what is their duty? What is their obligation to a client if they're an MSP or if they are a general IT provider? We're going to ask that question, and we're going to get some really good answers. All right. To get to the core question of what is an MSP, what is not an MSP, from a legal standpoint, right? We're thinking about all of this in the context of litigation, a legal dispute that has wound up into the court system in some way or fashion. I've asked my old friend, Rob Scott, to come into the program again. You heard Rob and I chat a lot through the pandemic years about a variety of topics, but this is the case we've all been waiting for, Rob, for 20 years, and this has got your name written all over it. So for those of you who don't know, Rob Scott is with Scott & Scott, a law firm out of Dallas, Texas, but he's also got a new thing that he's going to talk to you about called Monger. Rob, welcome back to the MSP Zone.
Thank you for having me, Charles, and always a pleasure to be with you.
All right. So real quickly, I know a lot of our members are familiar with you, but they know you from Scott & Scott. Could you give us a real quick overview of what you've been doing with Monger? Because it's really exciting stuff.
Yeah, well, thank you for that. Well, by 2020, I had hundreds of MSPs that were relying on our firm for customer contracting solutions. And I realized at that point that I had no way to really keep their agreements updated, but at the same time was encountering a lot of needs for changes based on regulatory climate, risk climate. And so in 2022, we launched the Monger platform, which is a cloud-based legal service that now allows us to host our clients' customer contracts in the cloud and to keep them dynamically updated as changes in the law or regulations or risk environment evolves. And so it was really born out of necessity for us to keep our customer contracts up to date. But we've had a really amazing response to our solution since we launched it in 2022. We now have over 400 MSPs on our platform, and it's growing very quickly, in part for the issues that we're going to be talking about today.
Exciting stuff, and we'll post some a link into the show notes so you can go check out Rob's new venture. It's not new; you've been doing it for a while now. But for those of you who haven't heard about it, you can go check it out there. All right, Rob, let's just dive right in. And before we get started, look, some of you may be saying, "Geez, why are you guys again talking about like MSPs getting sued?" And Rob and I talked a lot about whether we should. How much we should divulge here. And we're going to not, a lot of you already know who this company is and know about the facts of this case, or at least you think you know what the facts are. We're going to stay a little bit neutral and not call out people or company names, right? But we are going to be going right to the source, the actual legal complaint, and talking and asking Rob some questions about this. So, and in part because the company that we're talking about had a change. I think they merged with another company. And so we don't want to prejudice their good work that they're doing with this new merged entity. But it's very important, these topics. And so I'm just going to jump right in. Rob, could you give us a very brief overview of the fact pattern of this case as you understand it?
Yes, we're talking about a law firm that's fairly well known and a service provider that was responsible for, in part, delivering backup services that were provided through a prominent backup vendor in the MSP ecosystem. And there was an organized attack by a documented ransomware group that affected the law firm's business and thus gave rise to a lawsuit in court, state court, alleging that the service provider was negligent in the delivery of the backup services, and that injuries that they suffered as a result of the criminal acts of third parties resulted in a breach of an oral. And as a result, the law firm suffered $1 million in economic damages, which they seek to recover in the context of the case.
So when I read this, so I first became aware of this case through a news article, a blog. And the blog in the title claimed that the IT provider, as you called it, and as it's called in the complaint, so the complaint calls the entity an IT provider. I don't think anywhere it mentions MSP. I haven't read the entire complaint thoroughly, but I haven't seen the term MSP mentioned. Do you know if it's mentioned, Rob, in the complaint?
I didn't specifically look at it for that purpose, but we could certainly look into that and answer that. I think that the import here is, regardless of whether you're offering unique services on a project basis or you've styled them as managed services, it's inadvisable to do so without a written agreement. And this case raises questions about the duty of care that an IT service provider that gets engaged with someone regarding backup services as to what is the scope of that duty, notwithstanding the existence of a written contract. And I think that what our market suffers from is a great misperception that the duty of the MSP is ensure that their customers' environments are free from the criminal acts of third parties. And nothing could be further from the truth.
Now, Rob, I'll stop you there because I'm going to take you back to March 31st, 2008, Atlanta, Georgia. MSP World, you're sitting on the stage, I'm sitting on the stage, and we're taking audience Q&A, and we had just announced the very first cybersecurity insurance program for MSPs ever on the planet. And one gentleman in the audience, and we were talking about other types of, MSP best practices. Remember, this is 2008. I don't know if you remember this. This gentleman, maybe from the South, I don't really remember. It doesn't matter where he was from, but he said to the issue of should you have and do you have contracts, written contracts with your customers? I'm paraphrasing. I don't need contracts. My word is my bond, and I do business on a handshake. That seems to be what happened here with this IT provider.
Allegedly, based on the complaint, the complaint would have you believe that this law firm entered into an agreement with the service provider whose scope of responsibilities, including networking, security, and backup and disaster recovery, with no written agreements whatsoever. And they suffered a ransomware attack. They allege a negligence in the failure to protect the law firm from a ransomware attack that was allegedly perpetrated by organized crime. And that in any event, the oral agreement that existed was breached. So these are crazy concepts in the world of managed services. First of all, because as you mentioned, since 2008, we and everybody else in leadership roles in managed services have been disabusing people of the propriety of offering IT services without a written agreement. And, had this provider had an appropriate contract in place, those contracts would have prohibited recovery for the criminal acts of third parties, would have prohibited recovery for an act or omission of a third party service. And that's exactly what's being alleged against this MSP, who now has no written waiver of the right to sue for an act or omission of a third party, and no clear agreement that says that under no circumstances will the provider be responsible for the criminal act of a third party. So standard best contracting practices address this fact pattern, which is why you said we've been waiting for this case, because it's so obvious that a case like this demonstrates that providers need to have written agreements for their protection, and end users similarly need to have written agreements for their protection. And so if you're an IT service provider and you're thinking about investing in contracting, it's to protect both you and your customers.
So we're going to get, so let's address that first issue, because you said something really critical that I'm going to get to about whether the provider thinks they're an MSP. That's a separate issue. Whether the customer thinks the provider they're working with is an MSP. To be clear, and you're completely right, Rob, since 2008, before 2008, we have had a part of our code, part of the Cyber Verify, the UCS, the Unified Certification Standard for Cloud and Managed Service Providers, clearly states in Objective 10 that you have to have documented agreements. It's not just because we put it in there by accident. It's precisely for this. So to be a certified MSP, you cannot be a certified MSP as this fact pattern, sets out. This would not have been an MSP because they just clearly failed on that one critical element. The other thing I would like to ask you as a lawyer, how unusual it is for a client who also happens to be a law firm to be alleging the existence of a oral agreement. For those who haven't been to law school, Rob, what is the significance of a law firm client saying that there was an oral agreement that existed? Why is that?
Well, what it tells you is the appropriate types of agreements are not in place under this fact pattern. Otherwise, reference would be made to the signed agreements between the parties. And so you clearly have a situation where there's an absence or a potential absence of appropriate contracting. The reason that someone, for example, would plead both negligence case and a oral contract breach case, even though both could be quite flimsy on a legal basis, by pleading in the alternative, the plaintiff's lawyers give the client the better chance of having a theory of recovery that would not be thrown out by the judge. For example, the case of whether or not this service provider owed a duty of care that extended to protecting them with multi-factor authentication that they never ordered, they could lose that issue on a legal point and their case be dismissed without the opportunity to present it to a jury. In that fact pattern, the judge could throw out the negligence case, but still find that there's an issue of fact that must be tried whether or not an oral contract existed. And so this is a smart lawyering, and it's very commonly employed in cases of all types. And the strategy is called pleading in the alternative. I'm suing you either because you owed me a duty and you were negligent, or because we were entered into an oral contract. They can't have both under California law, but they can plead one or the other and see which one sticks.
So my initial thought when I read the article, which clearly said this was an MSP, it may have actually said MSSP. And I thought, this is really bad. So I wanted to see is it a member of the MSP Alliance? Were they a certified member? God forbid. Neither. They weren't a member. They weren't certified. And it wouldn't matter anyway. I mean, it doesn't mean that MSPs are not perfect, creatures. They make mistakes. But I was suspect. So I went to the company's website, and my first impression, now granted, this company is now merged, but my first impression of looking at that company was, this is not an MSP. I could be very wrong on that, but the complaint clearly says that the plaintiff is the law firm client, entered into the oral contract, Rob, that you just discussed, to have the IT provider design, install, monitor, maintain, troubleshoot, upgrade, and repair a computer network, servers, and backup system for the plaintiff's law firm. and it includes installation of cybersecurity software, measures, protocols, and monitoring to protect the plaintiff's network and data and prevent unauthorized access by hackers. To me, that reads not unlike the Rob Scott special of contracts that you have been putting out for MSP Alliance members for years. So there's an inconsistency here that it sounds like what would be in a normal MSP contract, but there was no contract. There was no written contract.
This is the problem that you get into when you don't have a written agreement, because the provider is saying, I just am doing projects for this person. And I'm doing them project by project. And they get a client that has a lot of projects. So now the MSP is, in the eyes of the law firm, I've got an MSP. The provider is thinking, I'm doing project. Why would the provider who's doing project work just automatically go and install dual factor authentication in a client's network?
So this is an issue of the customer thinking that they're engaged, but they're really dating. I'm paraphrasing here, but it's an escalation after a very serious moment where the customer says, wait. I thought we were in a real serious relationship with our provider where they were going to be doing all this stuff for me, but it turns out they weren't. This is not the first time we've heard this claim.
This is a microcosm of the problem that all MSPs face, which is there's a certain portion of the market and certainly a high percentage of their clients who have an incident who will first point the finger at the service provider and say, this is my service provider. Something bad happened to me, so it must be their fault. And nothing could be further from the truth. The MSP is not the guardian of things that could go wrong with all of the applications and all of the criminal acts of every bad actor in the world, no matter how well organized. And that's what these agreements that we recommend to clients are designed to make very clear. So if you have to go to court in a situation like the one we're talking about, you have two things that will set you free. Number one, a clear waiver that any act or omission of a third-party service won't result in any liability to the MSP. Number two, ransomware attacks are not your responsibility. If there's a ransomware attack, it's the client's responsibility to remediate, or if the MSP provides those services, to provide them. In addition, limitation of the types of damages that they're claiming. They couldn't recover $1 million from a client that's on our packages because we have limitations of liability that won't extend that high, that limit the recovery to some multiple of the fees paid. And so in so many ways, this MSP could have easily protected itself. And now, or service providers, you make a distinction between, what exactly is the service and what is the reasonableness of the expectations in light of the service? And we raise the question about, is this a service provider, an MSP? It raises the broader problem of not clarifying in writing what the scope of the services are, who's responsible for what, and what types of acts are excluded. And that's what the Mantra platform does today. And that's what we were recommending to people to implement in '08. And just so you know, even in '08, we laughed at this guy.
Rob, but we did. But there's now a very real flip side, which is there's two ways that I look at this. This was either a firm, a provider that was legitimately an MSP that had a non-MSP client try to establish a managed services relationship where one didn't exist, or this was not an MSP. This was a garden variety, and I don't mean any offense, but it's a break-fix company. It was a reactive IT. It was a VAR or some other type of firm.
Or stated alternatively, service provider that was offering services on a project or other basis other than on a recurring revenue basis.
But not an MSP.
I would say, I don't know what the terms of the alleged oral contract are, but in my opinion, managed services are defined as those IT services that are offered on a recurring basis and typically on long-term monthly recurring or annually recurring contracts.
So we say proactive. I have no problem with your definition, but let's take that for the second. It's either the MSP with a non-managed services customer wanting to establish that bond and that duty of an MSP relationship, or it was a non-MSP, call it whatever it is, with a client that thought maybe that they were dealing with an MSP, or maybe they didn't think. They're nevertheless trying to establish that same MSP relationship. Either way, you have a very real issue for the MSP and non-MSP channel community, and you've got a real issue on the end user consumer side. I think this is an existential question.
Well, let me see if I can interpret philosophy to law here. Since I have degrees in both, I got a decent chance. The existential problem that you're facing is this. What is the nature of the duty that a service provider owes to a client in the absence of a written agreement? And does that duty extend to offering the full suite IT managed services, including multi-factor authentication? Is there a tort-based duty of care for IT service providers? And if so, where is that line drawn? Legally speaking, the question will be, did this provider act in a manner that is consistent with a reasonable company in its position? I don't think that the courts will say an IT service provider has no duty of care whatsoever. I doubt that will be said. But what I think the court will say is that the duty of care does not extend to things that haven't been purchased or requested, and it certainly doesn't require the MSP to stand as the insurer for the criminal acts of third parties.
Time out, Rob. If I am a nurse, I am not going to be held to the same standard of care as a physician or a surgeon or a highly certified MD. Correct? Very different, right? Different schooling, different education, training, all of that. Different legal duty for that one professional versus that other professional. What I think I hear you saying is we are in muddy waters right now with regards to the duty of care that we're seeing this law firm client potentially trying to establish here, which is, if this wasn't an MSP, the law firm is trying to establish that they should have had an MSP's duty of care, which they did not, they're claiming, fulfill. That, I think, is a very dangerous territory to get into, because we have been saying for decades that MSPs have a radically different, elevated level of care to their customers that doesn't exist in IT or break-fix companies. Your thoughts on that?
Well, I think the question really, and what we stand to gain here, is to what extent will a court recognize a tort duty of care that can stand independently of a contract claim and alleged negligence? And that's an interesting, as you say, existential question. It highlights the importance, regardless of what level you're at, whether you're doing desktop support as a service, managed security services for critical infrastructure. It's important to have written agreements that specify all of these details so that in the event of a court case, it's abundantly clear what's going on. On the question of, a heightened duty for MSPs, I think that there is a responsibility on the MSP to protect the customer and to act as a reasonably prudent managed service provider, which includes, in my mind, ensuring that your customers have adequate procedural, technical, and administrative safeguards to safeguard customer information. Or stated alternatively, that your client can meet basic standards of insurability or regulatory compliance at a baseline level. And if you're not offering that, you're not helping yourself or your customers, and litigation of this type, I think, is just going to continue. And it's not entirely unclear to me that any of these court cases are going to draw a fine line that gives an MSP with no written agreement any sort of protection in court, near to the level that they could obtain by implementing a standard set of customer contracting solutions that other MSPs have been using, as you said, for 2 decades.
Rob, I think this is so critically important that this case I don't think has been resolved yet, so it's still active. But I think just the filing of this case and the fact pattern, it screams what I have, and I know you have, and I know RMM vendors and salespeople that work for RMM vendors who have been trying to, sell software to break fix companies that turn them into MSPs for decades. This is such an important issue because I have come across so many break fix companies who say, yeah, I don't want to be an MSP. I just like doing my thing. Well, your thing now just got brought into the crosshairs of a legal issue, which you're not going to escape because you may have a bunch of people who think you're an MSP. And unless you tell them otherwise in some overt, this whole case screams, you have to do something that says either I'm an MSP and here's my contract that says what I do, or I'm not an MSP. You better not treat me or think of me like an MSP. There's nothing MSP about what we have together. Like that just seems to me like one immediate outcome to prevent litigation.
Yeah, or stated alternatively, regardless of how you characterize your offerings, whatever they are, they're detailed, they're in writing, they're presented to the customers. It's clear what the scope of the responsibility is and what the exclusions are. What is it exactly that the provider is agreeing contractually to be responsible for, and what is the customer acknowledging or waiving the right to hold the MSP responsible? And regardless of how you characterize your services, these principles apply equally. But your point is there's a perception in the mind of the customer, regardless of whether you say you're offering managed services or otherwise, that your responsibility is to protect them from everything bad that can happen to them. And the only way that you'll be able to protect yourself in court from that kind of misconception is with a clear writing and an agreement that you could point to in court to say, no, Judge, we're not providing that. We're providing this. It's limited. We're not responsible for vendors' actions. We're not responsible for the criminal acts of ransomware attackers. And if you have that, just think about how much differently this case would go.
Yeah, it goes back to that too. I know you were there because it was in Texas. It was in fall of 2005. We had rescheduled. We had moved the MSP World Conference from New Orleans because of Katrina. And there were stories coming out even then, right? This was post Katrina by a few weeks of actual MSPs who said, we had clients who refused to buy backup as a service or backup services that we provided back then, a little different era in 2005. And they said clients were swapping out their tape drives themselves, and they found out, hey, they weren't actually doing any of that. And so they were like months behind in their data, archives, and they were in a very bad situation. And post Katrina, they were trying to rebuild the network and, put the data back where it's supposed to be, only to find out that there was, the stuff that was supposed to be there wasn't. And those are really foundational early lessons that are still, you see that in this case, right? There's, I don't know.
Yeah. I mean, it's the exact same issue. Like, the customer doesn't want to buy your cloud-based backup, so they want to continue doing the backup on their own, and then something goes wrong. Or there's so many situations in which there could be a disconnect between what the client thinks that they're buying and what the provider thinks that they're providing. And the only way to resolve that is with written agreements that are comprehensive and cover all the terrain. But if you think about it, the modern equivalent of that backup question after Katrina is MFA, which is the subject matter of this litigation that we're talking about today. Should MSPs allow customers to operate networks and applications without multi-factor authentication? Should MFA be considered core to managed services? These are all, as you say, existential questions, but that they have legal ramifications when it comes to the decisions that you make about the services that you offer and don't offer, and the various states of unprotectedness, if that's a word that you allow your customers to operate in. have an effect on your legal risk and exposure. And that's why so many of our clients now have standardized on a set of services or one or two options, but that there's a baseline, and they don't let their clients, cherry pick and choose which pieces of the solution they want to have. We have a certain way of doing this, and if it fits for you, great. If it doesn't fit for you, we're not going to manage your firewall. We're not going to allow you to co-manage this with a bunch of other people so nobody knows what's going on.
Yeah.
And so this case is the perfect storm because it alleges an oral contract. It makes a stretch about what the duty of care is for an IT service provider that causes everyone to open their eyes widely and say, that can't be the law. And it demonstrates when your clients suffer from the criminal act of a third party like organized crime doing ransomware, that comes back to you. And the only way that you can meaningfully grow and survive in this landscape as an IT service provider is with appropriate contracts. And this is especially true if you're offering managed.
So, Rob, I want to get to the issue of this trial court is not going to likely establish any meaningful precedent on managed services baseline standards, but they're a trial court. They're not set up to do that type of thing. Do you think that this case is going to likely rest on the existence of an agreement or the lack thereof?
No, I think that the judge will allow them to plead this case in the alternative, which means that they'll give the plaintiff the opportunity to defend likely a motion to dismiss on the existence of the tort duty, and may or may not find that there's a fact issue there. And the pleadings regarding a potential motion to dismiss on the issue of duty would be greatly watched and very important to the existential question that we're examining. And I also think that they're going to give them the opportunity to allege an oral contract if there is no writing or series of writings that would establish that. In the context of in the context of both, we may see that the court finds that there is a circumstance where a case like this could go forward, and we'll just have to continue watching. For the industry, my hope would be that a case like this would be dismissed for failure to state a claim in tort, and or because there was an oral contract that's alleged, the tort claim can't exist outside of that. So that case is either dismissed because there's no duty, or it can't coexist with the contract claim. Yeah. And then to the extent that you claim an oral contract, let's hear what you say about that. And maybe that case goes forward. But it's hard to believe how that oral contract would include a guarantee against the criminal acts of third parties.
I like that defense of, we were just hired to set up their network. That's it. We're not an MSP. Don't treat us like an MSP. There was no agreement. No one wrote anything down. That should be Exhibit A in our we're not an MSP, case, and dismiss it. That's assuming that that's actually what they were doing. We don't know. You said that very clearly. We don't know. But look, I think the takeaway, and just a sidebar question or point, if you want to listen to more of this type of conversation and more of this, obviously, go check out Rob's site, Monger, and sign up with them. But come to Vegas in September 12th and 13th and listen to Rob yourself. And we're going to have a ton of discussion about this and other related kind of legal MSP issues, which I think are really cutting edge and just emerging. But Rob, I think that this is one of the best reasons, and this is not the only case. There's a number of other cases where there's an allegation of my MSP failed to protect me against a bad thing, typically a ransomware attack that was successful. This one is so unique because it's ambiguous, lack of a written agreement, lack of a real meaningful existence that this was an MSP. We don't know, but so many things are going to be critical to see how this case unwinds and evolves. But I know we're
definitely going to be monitoring the pleadings. We'll have an update by MSP World if there are any. And it's just one of, like you said, a number of cases that demonstrate that IT services are risky businesses, that they should be performed pursuant to, contracts that are purpose built for the services being offered. And the idea of offering IT services of any type that implicate cybersecurity on an oral agreement is a recipe for disaster, as this provider in this case that we're talking about is experiencing. And so the sad thing for me is it can be easily avoided, and just want to get the word out that, if you've been procrastinating about dealing with your customer contracts or approaching your clients to get them into appropriate agreements that protect you and them, this is a wake-up call for you to stop procrastinating for your own personal benefit, for the benefit of your family and your employees. These types of cases can destroy your business.
I mean, that is such a huge understatement, what you just said, Rob, because I look at all those break-fix companies who've told me and probably told you, I don't want to be an MSP. I like doing what I'm doing now. Mm-hmm. As if you're still at risk. Guess what? You're still going to be hauled up there in front of some judge, potentially, because you've got a client that thinks you're doing something else that you don't do. And that to me is the whole, that's going to be a big ongoing conversation, Rob.
And the biggest challenge is, just having experience litigating these cases. And this is understandable. These judges are not IT people.
Yeah.
When one